Hello and welcome to Sensational South. I'm Harish Upadhyay. Over the next 30 minutes, we bring you all the major stories and newsmakers from across South India. Our top story today comes from Tamil Nadu and Kerala. It's once again governor versus the government. Both the states have approached the Supreme Court seeking directions from the Supreme Court, asking Raj Bhavan to decide on pending bills that have been with the governor for a few months or years in few cases. Will the Supreme Court intervene? What's the way forward? We'll debate that. But first, the story.
Three of the 5 southern states are at loggerheads with the governor: Kerala, Tamil Nadu and Telangana. Chief ministers and governors not seeing eye to eye over how the administrative work is being carried out. In Kerala, the state has decided to move court against the governor. In its petition to the Supreme Court, the Pinarayi Vijayan government argued that Governor Arif Mohammad Khan has failed in his constitutional duties by unreasonably delaying assent of 8 bills passed by the legislature. They claim that 3 out of the 8 bills have been pending with the governor for more than 2 years. 3 other bills have been pending for more than a year.
Several bills are pending for years. 4 bills are pending before the governor for his clearance the last 2 years. Some bills are pending the last 1 year. Then as per constitution, if the honorable governor has any objections or any clarification is required, he can send it back to the legislature.
Kerala government's move comes just after Tamil Nadu towed a similar line. Stalin government approached the Supreme Court accusing Governor Ravi of obstructing the Legislative Assembly from carrying out its duties. In its petition, DMK alleged that Ravi has not only kept multiple bills pending, but has also not sanctioned the investigation and prosecution in several corruption cases. The oldest legislation pending with the governor dates back to 2020, and it includes a bill that will shift power of inspection and inquiry at universities to the state instead of the governor, who is the chancellor. As the war of words escalates into a legal battle, BJP is blaming the state government's inefficiency, calling the fight against governor nothing more than a diversionary tactic.
The best way for a state government to hide its inefficiency or to hide the public anger against its governance is to go after the governor. And in Tamil Nadu, the DMK government is laying this trap of going after the governor. The governor is perfectly within his rights to do what is he doing now.
In March this year, Telangana too had knocked on the doors of Supreme Court, making similar allegations. Back then, the court had observed that governors must return bills as soon as possible. So why is this an issue? Bills passed by legislatures become law only after the governor signs off on them. Article 200 of the Constitution gives governors the power to either grant their approval to a bill, reject it, or in some cases, reserve it for the President's consideration. While rejecting the bill, the governor may suggest amendments. However, legislature is not obligated to accept these suggestions and can pass the bill again in its original form for the governor's approval. On this occasion, the governor must either give assent or reserve it for President's consideration. But until the governor decides, there is no forward movement, and that seems to be the bone of contention. So what's the road ahead? Is a direction from the topmost court of the country the only solution to the impasse, or will it be resolved amicably? Bureau Report, CNN News 18.
In fact, to debate this further, we have an eminent panel joining us today. We have a Supreme Court advocate, Mr. Kaleswaram Raj, joining us. We also have Mr. Dharnidharan of the DMK. I'll come to you, Mr. Kaleswaram Raj, first. How do you see these developments? Do you believe that the Supreme Court will entertain both these pleas filed by Tamil Nadu and Kerala? Will there be any sort of order or a direction at all?
Thank you for choosing this extremely important topic for discussion. I congratulate you for that. With respect to your question, I should say that the development as such is something which is very, very unfortunate. Because an elected government had to approach the apex court for getting clearance for certain bills by the governor in itself is extremely unfortunate. That is antithetical to democratic ethos. And I would say that the Kerala government, as far as the Kerala government is concerned, it has waited till the end. They have shown utmost patience before going to the Supreme Court. And as regarding the outcome, I expect that you know that Dr. Ambedkar has famously said that the governor has only certain duties. He does not have any function to carry out. He has the duty to have his opinion on the bill, and the word used under the proviso to Article 200 of the Constitution is provided that the governor may, as soon as possible after the presentation to him of the bill for assent, return the bill if it is not a money bill, together with a message requesting that the House or Houses will reconsider the bill. So either he will have to accept it as such, to give assent as such, or if at all he is skeptic about it, he will have to send it back as soon as possible. That's the word used. Now, coming to the incident, you know, the months have lapsed. Almost a year has lapsed, and more than a year in the case of certain bills. This is extremely pathetic. And as regarding the outcome, what I expect is the Supreme Court will not only entertain this, in all probabilities, these concerned governors may be facing strictures from the court. There is every possibility to have certain strictures, judicial strictures by the apex court as against these governors. And at the end of it, it is their own creation. They only invited it. And I should also say that this reflects a kind of agenda from the regime at the center. They are in one way or other discrediting the constitutional institutions, including the gubernatorial offices across the country. Wherever the opposition is in power, this is what is happening. This is something unfortunate, something unacceptable.
Okay. I'll come back to the question on how the court might view this, but quickly bringing in Mr. Dhanidharan. Mr. Dhanidharan, how do you see the argument of the Raj Bhavan, especially in Tamil Nadu, whenever they've rejected a few proposals by the government or sat on their bills? There is some sort of a reasoning given. Do you see that it will be the same argument that the Raj Bhavan will place in front of the Supreme Court?
See, this incumbent governor has insulted the seat of governorship forever. He doesn't behave like a governor, but he behaves like a RSS ideologue or a BJP spokesperson. Wherever he goes, he wants to create controversy by speaking something that is of no interest to the people of Tamil Nadu. He only wants to hurt the sentiment of people of Tamil Nadu, right? We live in a democratic country. 8.2 crore people of Tamil Nadu elect their legislative members. The MLAs in turn go and elect a chief minister. Chief minister forms his council of ministers. So the legislature creates a bill. So when legislator creates the bill, what is it representing? It is representing the will of the people, because people are electing these MLAs, right? So why is it called legislature? Because they legislate laws. So what is the role of a governor? Like the honorable lawyer who spoke to me earlier said, he has only duties. He has no powers. He has no functions. He has to only sign and send it back, because whatever is coming from the assembly represents the will of the people of Tamil Nadu. Who is he to go and question that? Okay, he has some clarification, right? As per the constitution, he can send it back ASAP. And if the council of ministers and legislature thinks that no, we do not want amended, he'll have to sign, right? That is democracy. If an appointee can go and decide on bills, decide what is wrong or right, then why have democracy?
Mr. Dharani, in the case of appointment of vice chancellors to 3 universities, he might come out and say that he believes that it doesn't fulfill the criteria or they're not eligible for that post. That's one argument we might see from the Raj Bhavan. How will the state government tackle that, sir? And are you confident that the Supreme Court will get into argument in this, because it's almost the judiciary versus at some stage the Raj Bhavan then?
Sir, first of all, who is he to decide on vice chancellor? That is why we also passed one other bill in which we said that he has no role to play in selection of vice chancellor. Who's funding the University of Tamil Nadu? Tamil Nadu government. Where does the Tamil Nadu government get its money from? People of Tamil Nadu's tax money, right? Where does the Tamil Nadu government get its mandate from? Like from the people of Tamil Nadu. In a democracy, who is supreme? The people. Who has given the power to the DMK government? The people. In a democracy, that's how it should function. So who is he to come and say all that? Okay, I have one more question. BJP says they are against corruption. They're creating this lie. Of course, the most corrupt party is BJP. Let me not go into that. But, right, there is a bill pending with the governor to sanction prosecution and investigation for various crimes of corruption involving moral turpitudes of public servants, and first files pertaining to certain premature release of prisoners. So my question is, so this is very important. So the files pertaining to corruption of certain AIDMK ministers and bureaucrats who served under these ministers have been sent to the governor, because only governor can give permission to prosecute them. Why is he sitting on it for 7-8 months? Is it not quid pro quo that I can accuse the governor that he's taken bribe from the AIDMK ex-ministers and sitting on the bill? Is it befitting of a position of a governor? Why is he doing that? Right. I'll tell you one example, sir. There was one university in Tamil Nadu where handicapped people were not allowed. It was a very bad law. Somehow this law had not come into the attention of the government. Our chief minister immediately took notice of it, passed a bill saying everyone should be allowed. But even on that bill, he was sitting for months. There was another bill in which we want to give preference to SC/STs in Tamil Nadu tenders by amending the Tamil Nadu Tender Act. Why? Because representation of SCs and STs in participation of tenders were less. In social justice government, everyone should be given an equal opportunity. That bill he was sitting. Why? And another foremost important thing is NEET. Right? All political parties except for a party called BJP, which has less than 2% vote share, right, are against NEET. Right? And 99.9% of Tamil Nadu people are against NEET exam. Tamil Nadu government is passing a bill and sending it to him. Who is he to comment and saying, no, it is social justice?
So what's the way out is the question now. I'll take you to Mr. Kaleshwaram Raj.
Let me just add on. Sir, I just want to add on one more thing. I think Supreme Court will definitely tell the governor to pass these bills. At least most of the bills, he'll request him to pass. So what happened in release of Perarivalan, where court said that, listen, you have to listen to the elected government. That's all.
Okay. You are saying the court will act, but the larger question here is the confrontation can't go on forever, and you can't approach Supreme Court for every bill that gets stuck for months and years. Mr. Kaleshwaram Raj, we've had at least 2 commissions talking about the role of the governor, the selection of the governor, what should be the criteria. Do you see now the time has come that the union government in fact goes in for some sort of a relook or review on the function, how the governor functions, and the role of the state government there?
That's a relevant question, Mr. Harish, but I would rather think that the Supreme Court will have to give certain guidelines in this regard, because the Constitution, Article 200 especially, unfortunately, or fortunately for the governor, does not fix a time limit for giving assent to the bill or for sending it back for reconsideration, etc.
Yes.
So these the new writ petitions which are coming up before the Supreme Court will pose that question as well. So most probably I find some possibility for making a kind of a court-made law in this regard. The Supreme Court once makes a law, it becomes the law of the land, and it is binding on all concerned. For the entire nation, it is binding. Therefore, interpreting Article 200 of the Constitution, the Supreme Court may be called upon in this case, and I think some prayers are to that effect. At least in the writ petition filed by the state government of Kerala, that is one of the prayers.
Yes.
So the court will be called upon, and court will have to decide or fix rather a time limit, a reasonable time limit to take a decision when a legislature has presented a bill for assent before the governor. And ultimately, you will find, there are 2 problems. The lawmaking is the prerogative of the legislature. That we have to understand. That is how the division of power has been laid down in the Constitution. That is how the Constitution works. That is how democracy gets a meaning for itself. So, division of power. Once legislature passes a law, if at all, let us assume that the law is defective or for some reason or other it is untenable, as it has been contended by certain advocates, then it is for the court to look into that. It is the prerogative of the court to have a judicial review over the legislation, not for the governor. Governor's function is different. Governor's duty is different. And this happens probably because, this is the constitutional frame, and this happens, this recurring one after the other in several states, especially opposition states. I would think that this is happening because the regime at the center does not believe in the ideology of the Constitution. That is the root, or perhaps that is why it is happening. They are discrediting the institutions.
Okay, Mr. Kaleshwaram Raj, since you brought up this topic of the regime at the center, Mr. Dharnidharan, many would say that when the UPA was in power for 10 years, these 2 committee reports, including the Sarkaria Commission report, was also in front of the UPA government then. nothing much changed. You did not look at the functioning of the Raj Bhavan, the governor, if anything needs to be changed. So many would say that the UPA over 10 years, which we were part of, didn't do much on this aspect.
Yeah, I don't think the governors have behaved in this manner in living memory. I think a lot of constitutional experts have written on this. For example, nowhere in the history of Bank had the governors had the audacity to revoke pleasure. For example, this governor went ahead and wrote a letter revoking his pleasure on continuance of Senthil Balaji as a minister. But the fact of the matter is, how does the governor derive his pleasure? He derives his pleasure from the Honorable Chief Minister of Tamil Nadu, right? So basically, the pleasure which the governor has is based on the mandate which the government has. Both are intertwined. The governor cannot act independently. The moment the moment the chief minister will lose his mandate or confidence, only then he can revoke the pleasure, not the other way around. And the chief minister's prerogative to have anyone and everyone as a minister. We saw it in Kerala, we saw it in Tamil Nadu, we are seeing it everywhere.
In fact, it's Tamil Nadu and Kerala. We've also seen earlier Telangana also having similar issues. We will have to see if the Supreme Court will give a clear direction to Raj Bhavan in both these states on how soon they should act on a bill sent by the state government. Thank you, Mr. Dharnidharan and Mr. Kaleswaram Raj, for joining us today. We'll keep tracking this story, but time for a break now. On the other side, we'll get your exclusive interview.